Hi everybody, hello Bay Area. Welcome to another episode of Ask Me Anything. My name's Yaasha Sabba. I'm a personal family lawyer helping customers do estate planning, asset protection, as well as business planning. We're going to answer your questions today, so let's get started. First question. My parents are living in their own home and they are both listed as the owners. They are already 88 and 91 years old, but they refuse to draw up a will. Do you recommend a trust? I am their son and I want to do everything possible to ensure that their home and assets are protected from the government. Well, if your parents don't want to draw up a will, that's their prerogative. They don't have to do it. If they don't have a will, guess what? The government has a will for them. If they're here in California, then there's a law that says when they pass away, if they're joint owners, when one of them passes away, it looks like one of them's 91 years old, kind of close towards that end. Let's hope they go to 100. Make that centennial. Then what that means is the other co-owner is going to inherit the home. No court, no nothing. That's actually automatic. You just let the county know. You send them a death certificate and it's done. But when they both pass away, if they don't have a will, it doesn't matter. The house, the title of the house will go into probate. This is a court process to help us figure out who should receive this home. Now, you're their son. If you're their only son, then the home is going to go to you. But in order for you to change title from their names to your name, you're going to need an order from the court. You have to go through probate. So even if they have a will, and if they say where they want it to go, I want it to go to my son, I want it to go to charity, I wanted to go to our next door neighbor, our attorney, yeah. But if they have a will, the will still has to go through probate. So generally, yes, in California, because of the cost of probate, because of the time, the public nature of the court proceedings, I personally do advocate that trusts are a great way to go. It's not for everybody, so it's more on what I like to do is educate you, educate the community, and let you decide what's right for yourself. But if your parents set up a trust and they move the home into that trust, when they pass away, you're avoiding probate. You don't have to go to court. It's all private and it's all automatic. It happens with the trustee transferring title from the home over from the trust to you. Or if your parents have a good attorney and that attorney educates them, your parents might have the option to set up provisions within the trust to keep the home in the trust for your lifetime so that it is protected from your life sticky situations, your creditors, your divorce, your lawsuits, your bankruptcies. This is one of the best gifts that parents can give their children, is setting up what I like to call these lifetime asset protection trusts. And your inheritance that you receive from them will remain in the trust. It can continue to grow. You can sell the home, take the cash, invest it in the market, sell the home, buy a new home. You could do whatever you want. The money doesn't have to be stale. And as long as it's in this trust, it can grow. And that money, as it grows, is protected throughout your life. And then you can create an estate plan that after your life, how do you want your inheritance as well as your own personal assets to be passed down to your loved ones. You can do the same way your parents have done to take care of you, or you can do something else. But for now, it sounds like your parents aren't even thinking about that. Probably the reason is because they just have a lack of education and they don't understand how much of a hassle and turmoil you are going to be in after they're gone to settle their affairs. It's not an easy process, but there is a plan. There is always a plan. You're either on the government's plan or you are on your own designed plan. Whether it's a good design or bad is another issue. But I don't think this home will go to the government. The only time assets go to the government is when nobody steps up after someone dies to claim it. Right now, the state of California has $9 billion of unclaimed property. $9 billion. Oh my gosh. Do you know how much money that is? They make about $100 million off that, the interest of that unclaimed property. And that's like 20%, maybe a little less of the general fund budget. It's the slush fund for the state. So does the state have an economic incentive to give that money back? Not really. But if you want, this is unclaimed property, not just from people who passed away, but also people still living. So if you want, I suggest you go and Google Unclaimed Property California. You'll find the link to the state controller's website where you can search a database, input your name, input where you live, and you'll find money for yourself. I found $500 for my sister once, and she said, Yaasha, do you want to go get it for me? I said, yeah, you want to give me 10% of it, you know? So Everyone can do this. I do this on a periodic basis with my own family. I checked the unclaimed property database, found $50 for my dad, 5 cents for my mom. She said, forget it. I don't want to let the government have 5 cents, right? All right, next question. Is the executor of my father's will required to let me see it? His only heirs are me and my sister. Okay, so if your father recently passed away and he has a will and somebody's named as the executor, that's great. That means your father's organized, he's created a plan, and if you're not the executor, you're just the beneficiaries, or maybe you're not the beneficiaries. Either way, in order for that will, for that executor to do their job, for them to actually legally be appointed as executor, they have to go to court. They have to go to probate. All wills must go to probate. There's no such thing as a private will. That's BS. Whoever told you that, what you see on Netflix, on Better Call Saul, the lawyer reading the last will and testament in the privacy of their office, that's Hollywood. All wills have to go through probate because only a judge can authenticate a will, all right? So if you don't want your family going through a public court process, which in California takes about 8 to 12 months to get in and out, and that's if there's no problems, no creditors, no issues whatsoever, that's rough. The money's tied up for almost a year, and there might be surprises or hurdles, and it is incredibly expensive. It's very expensive to take your assets in probate and out. And unfortunately, in this case, your dad has a will. You guys are going to go through probate. But guess what? That's not a bad thing, because in probate, all the heirs of your dad's estate, even people, if he's disinherited you, for instance, if your dad didn't like you and he disinherited you in his will, that's his prerogative. But as an heir of his estate, you are entitled to notice and you are entitled to a copy of the will that's being lodged with probate. And even if they don't give you a copy of the will, don't worry, because right once the probate's opened, it's public. You can go and get it yourself. Yes and no is the answer. It all depends. But one thing is for sure, in order for that will to be read and the executor to be appointed as the executor, they have to open up a probate with the local county court that your father passed away in the county your father passed away. So you can go look up the courts to see if one has been opened. And they have to give you notice as an heir of your father's estate. Even if he's disinherited you, you're still an heir. You still get notice because you can contest. You should have the opportunity to contest if the will was created for whatever reason, undue influence, someone illegally, that kind of stuff. If any funny business had at the last minute of your father's passing. But if the will is legitimate and he disinherited you, then you don't get anything, but you at least now have that information. It doesn't sound like that's happened. I'm just giving you a reason why you wouldn't get a copy of the will potentially, but all heirs are supposed to be notified of the probate, and then from that notification, you get a copy of the will. If you are a beneficiary in the will, then yes, absolutely. You and your sister deserve a full copy, and the executor is supposed to be giving that to you right once they get appointed by the judge as executor. Just because the will says they're the executor doesn't mean they're the executor. They have to get appointed by a judge. The will has to be authenticated by a judge, all right?